Imagine a world where your very voice carried less weight, where your choices were made for you, where your destiny was sealed before you even understood what destiny meant. What if your rights were not your own, but merely an extension of the men around you? What if seeking justice was a journey fraught with insurmountable walls simply because you were born a woman in 830? Number 8. Denied a voice in the halls of judgment in the year 830 AD, across vast stretches of what we now call Europe, a woman's ability to stand before a judge and speak her truth was often like trying to catch water in a net. The very concept of her having an independent legal persona, a standing in court equal to a man's, was largely uncharted territory. Imagine a young woman, perhaps named Elara, living in a small village nestled within the Carolingian Empire. Her family's small plot of land, their only true wealth, is suddenly claimed by a distant male relative, a powerful and influential lord from a neighboring county. Elara watches her father, a simple farmer, try to argue his case in the local lord's court. Proceedings are intimidating, filled with men in positions of authority, their faces stern and unyielding. But what if Elara herself had witnessed the original agreement, a promise made years ago? What if she held a crucial piece of knowledge, a memory of a boundary marker, or a sworn statement from a now deceased elder? She would find her path to the witness stand incredibly difficult, if not completely blocked. The legal systems of the time, often rooted in Germanic tribal laws, Roman law remnants, and burgeoning canon law, frequently stipulated that a woman's testimony was either inadmissible entirely or held significantly less weight than that of a man. Why was this so? It was often due to deeply ingrained societal beliefs about women's inherent nature. They were seen as less rational, more emotional, easily swayed, and therefore less reliable as witnesses. This wasn't just a casual dismissal. It was a foundational principle woven into the very parchment of justice. A man might swear an oath on a sacred relic, his word carrying the gravitas of his honor and his position in the community. A woman's oath, however, might be viewed with suspicion, as if her feminine sensibilities somehow tainted its truthfulness. Consider the implications. If Elara had seen the true boundary, if she could describe the specific tree or the ancient stone that marked the family's land, her knowledge might be crucial. Yet, if her testimony was deemed insufficient, if it needed to be corroborated by a male relative, a brother, or an uncle, then her independent observation became worthless. What if no male relative was willing or able to speak on her behalf? Perhaps out of fear of antagonizing the powerful lord. Her truth would remain unspoken, unheard, in the very place where justice was supposed to be dispensed. It was a systemic barrier, an invisible wall that prevented women from directly participating in the very process that determined their fate. Their very right to be heard to articulate their experiences and observations was curtailed, placing them in a precarious position where their reality could be denied simply by the legal structures of the age. This denial of legal standing extended beyond witnessing land disputes. It impacted everything. A woman who was accused of a crime, even a minor one, might struggle to defend herself. Her words might be picked apart, her demeanor scrutinized, not for honesty, but for signs of perceived feminine weakness or deceit. If she was a widow, she might be forced to rely on a male guardian to represent her in court, a relative she might not even trust. If she lacked such a guardian, her position became even more vulnerable, leaving her exposed to accusations without a formal champion to speak on her behalf. Her very existence in the legal realm was often mediated through a male, a father, a husband, a brother, or a lord, meaning her agency was perpetually secondary. The scales of justice, even when metaphorically blind, were often tipping not by the weight of truth alone, but by the weight of gender. Number 7. Barred from controlling their own inheritance. Imagine you were a woman living in 830, perhaps named Isolde, whose father has just passed away. He was a craftsman, a skilled worker who had accumulated a small but respectable amount of property, a comfortable dwelling, a workshop with valuable tools, perhaps even a few acres of fertile land outside the village. You have brothers, but you are the eldest, and you have worked alongside your father for years, learning the intricacies of his trade, understanding the value of his tools, and knowing the lay of the land he cultivated. You believe you are perfectly capable of managing this inheritance, continuing his work, and ensuring the family's prosperity. However, the legal and customary practices of 830, and particularly across much of Western Europe, would have swiftly disabused you of this notion. While specific laws varied from region to region, a bit different in Anglo-Saxon England than in Lombard Italy or Frankish Gaul, a common thread ran through them all. Property was primarily considered a male domain. Inheritance laws, such as Salic law in the Frankish kingdoms, often explicitly excluded women from inheriting land, especially Salic land or allodial land, land owned outright. Daughters might receive a movable dowry upon marriage, perhaps some household goods, livestock, or a sum of money, but rarely the ancestral lands or fixed property that formed the backbone of a family's wealth and power. Your brothers, even younger ones who might have less experience or inclination for the craft, would likely inherit the dwelling, the workshop, and the land. You, Isolde, despite your knowledge and dedication, would be largely overlooked in the direct line of inheritance for the primary assets. Why was this so? Prevailing logic was that land, and by extension, power, needed to remain within the male line to ensure continuity, stability, and the ability to fulfill feudal obligations like military service or providing men-at-arms. Women upon marriage were seen as transferring to another family, and allowing them to inherit land might lead to its dispersal outside the family lineage, or even into rival clans, which was seen as a threat to the established social order. This meant that even if you were the most competent, the most intelligent, or the most hard-working among your siblings, your destiny regarding the family's wealth was often sealed by your gender. Your share, if any, would be a dowry, a one-time settlement given to you upon your marriage. This dowry was not truly yours to control either. It generally became the property of your husband upon marriage, or at least he had the right to manage it and benefit from its proceeds. You might have had some limited rights to its return if your husband died or if the marriage was annulled, but its active management was usually out of your hands. The lack of control over inherited wealth meant a profound lack of independence. If you couldn't inherit the land, you couldn't farm it. You couldn't control its produce, and you couldn't leverage it for economic power. If you couldn't inherit the workshop, you couldn't continue your father's trade as an independent master. You would be dependent on your brothers, or more likely your husband, for your economic sustenance and social standing. This system effectively trapped women in a cycle of dependence where their financial security was perpetually tied to the men in their lives. The denial of direct inheritance and independent control over property was a fundamental way. Justice was withheld, preventing women from building their own economic futures and asserting their independence in a world where land and tangible assets were the very bedrock of power and stability. Their contributions, their labor, their knowledge often translated into little to no direct economic control, a deeply inequitable distribution of resources. Number 6. Entangled in marriages without consent or recourse. Imagine you are a young woman, perhaps named Lyra, living in a small, bustling town in 830. You have dreams, perhaps of learning to weave intricate tapestries or tending to the sick. But as you approach marriageable age, a new reality begins to set in. One evening your father calls you aside, his expression serious. He informs you that a marriage has been arranged for you. Your husband-to-be is a man from a neighboring estate, older perhaps, known for his stern demeanor or even his quick temper. You have no say in the matter. Your feelings, your aspirations, your very consent are not consulted. They are simply not relevant to the transaction. This scenario was not an exception, but a widespread norm in 830. For most women, particularly those of higher social standing, marriage was fundamentally an alliance, a contract between families, a means of securing property, consolidating power, or cementing social bonds. Love, affection, or personal preference were secondary, if considered at all. A father or a male guardian held the authority to arrange a marriage for his daughter, niece, or ward, often without any need for her consent. The young woman was, in essence, a valuable piece of the negotiation. Her future intertwined with the strategic interests of her male relatives. Once married, a woman's identity often became subsumed into her husband's. She became fine covert, a legal concept prevalent in many regions, meaning her legal identity was covered by her husband's. This had profound implications for her rights within the marriage itself. She could not own property independently, could not make contracts, and in many places, even her dowry became her husband's to manage. Her body was considered his property, and within the confines of marriage, the concept of marital non-consent or spousal assault was largely unknown, and certainly not a recognized crime. Her husband held authority over her, and his word was often law within their household. What if the marriage proved to be unbearable? What if the husband was cruel, abusive, or simply neglectful? For Lyra, seeking a divorce or annulment was an almost impossible quest. In many regions, particularly those influenced by Christian canon law, marriage was considered a sacred, indissoluble bond, broken only by death. Annulments were rare and difficult to obtain, usually requiring proof of pre-existing impediments like consanguinity, being too closely related, or non-consummation, rather than marital misconduct or incompatibility. A woman could not simply petition for divorce on grounds of unhappiness or ill treatment. Even in cultures where divorce was technically permissible, like some early Islamic legal traditions, the right to initiate it overwhelmingly favored the man. A husband could often repudiate his wife with relative ease, while a wife's avenues for seeking separation were severely limited, and often required strong, provable grounds that put her in extreme danger or spiritual peril like apostasy. If Lyra were to flee an abusive marriage, she would have no legal standing, no recourse. She would likely be considered a runaway, her property, including her dowry, lost, and her reputation irrevocably ruined. She might be forced back to her husband or face destitution and social ostracism. The lack of a right to choose one's spouse, coupled with the profound difficulty in dissolving an oppressive marriage, meant that women in 830 AD were frequently trapped in situations they had not chosen, and from which they had no legal escape. Their autonomy over their most intimate relationships and their personal safety was severely compromised, leaving them vulnerable to the whims and actions of their husbands without any practical path to justice or freedom. Their entire existence was often defined by the marriages arranged for them, rather than by their own will or desires. Number 5. Winnable to violence, without justice for sexual assault. Imagine a woman named Seraphina living in a rural village somewhere in the Byzantine Empire in 830 AD Bill. One day, a powerful man, perhaps a local landowner or a member of a noble family, assaults her. Seraphina, deeply traumatized, wants justice. She wants the man punished for his heinous act. But as she tries to navigate the channels of justice, she quickly learns that the path is not only arduous but riddled with biases that actively work against her. In 830, and across many cultures, the concept of sexual assault as a crime against a woman's bodily autonomy was not a primary legal consideration. Instead, such acts were often viewed through the lens of property, honor, and family. If Seraphina was unmarried, the assault might be considered a crime against her father or guardian, as it diminished her value as a potential bride or shamed her family. If she was married, it was seen as a crime against her husband's honor and property, rather than a direct violation of her person. The emphasis was often on the damage to the male's reputation or the disruption of social order, not on the profound trauma and injustice inflicted upon the woman herself. Bringing a case forward was incredibly difficult. First, the woman's credibility was often questioned. Society frequently placed the burden of proof, and often the blame, on the victim. Was she dressed provocatively? Was she out alone? Did she resist enough? These were questions that might be implicitly or explicitly asked, shifting the responsibility from the perpetrator to the survivor. Her reputation, her purity, her past actions, even rumors could be brought into question, effectively putting her on trial rather than the accused. Her word, as discussed earlier, might carry less weight than a man's, making it harder to prove her case without independent witnesses, which were often impossible to come by in such private acts. Furthermore, the legal penalties for perpetrators of sexual assault were often shockingly lenient, especially if the perpetrator was a man of high status. In some legal codes, the punishment might be a fine paid to the woman's father or husband, or perhaps forced marriage to the assailant. The idea of lengthy imprisonment or capital punishment for such a crime, unless it involved a virgin of high social standing and was considered an extreme affront to a powerful family, was rare. The focus was often on compensation or restoration of order, not on retribution for the victim. For Serafina, this meant that even if she endured the humiliation of testifying, even if her word was believed, the consequence for the assailant might be a mere slap on the wrist, a financial penalty that did little to acknowledge the profound violation she had suffered. In some instances, particularly if the woman was of a lower social class, an enslaved person, or a prostitute, the act might not even be recognized as a crime at all in the eyes of the law. Their bodies were often deemed to have no inherent honor to defend, or their status rendered them without legal protection against such violations. The societal structures, religious interpretations, and legal precedents of 830 had created a deeply hostile environment for women who were victims of sexual violence. They faced an uphill battle for recognition, for belief, and for any meaningful form of justice. Their experiences often dismissed, their pain minimized, and their assailants frequently allowed to escape with little accountability. The very concept of justice for such a grievous act from a woman's perspective was severely and systematically denied. Number 4. Bound by religious and social doctrines of inferiority. Imagine you are a bright and inquisitive woman, perhaps named Theodora, living in a bustling city like Constantinople or Rome in 830 AD. You observe the world around you. You listen to scholars, you engage in conversations, and you naturally form your own opinions and ideas. Yet everywhere you turn, from the sermons preached in churches to the laws decreed by kings and emperors, you encounter a pervasive message. Women are fundamentally different from men, and often inherently inferior. This wasn't just a casual societal observation. It was a deeply ingrained worldview, cemented by both religious doctrine and the prevailing social structures of the time. The dominant Christian theology, for instance, often interpreted biblical narratives in ways that emphasized female subordination. The story of Eve's temptation in the Garden of Eden was frequently cited to portray women as more susceptible to sin, weaker in intellect, and needing male guidance and authority. Saints and theologians frequently wrote treatises and sermons that explicitly stated women's secondary role, advocating for their silence in public life, their submission to their husbands, and their primary function as wives and mothers. If she were to express a strong opinion in a public gathering, or even challenge a male relative's decision, she might be seen as overstepping her God-given bounds, acting against divine order. Her intellect might be dismissed as feminine irrationality, her assertiveness as unseemly boldness. The very framework of society reinforced by religious authority dictated that women were meant to be modest, chaste, obedient, and confined to the domestic sphere. Their role was primarily to bear children, manage the household, and support their husbands. This pervasive doctrine of inferiority directly impacted women's access to justice. If a woman's testimony was doubted, it was often rooted in the belief that she was inherently less rational or more prone to deception. If she couldn't inherit land, it was justified by the idea that women were not suited for public responsibility or leadership, and property needed to be managed by men. If she was abused within her marriage, the religious and social teachings about a wife's submission often meant that intervention was rare, as it was considered a private matter within a divinely ordained hierarchy. Where the husband was the unquestioned religious ideas, men were the public figures, warriors, rulers, landowners, priests, and merchants. Women were the private figures, wives, mothers, daughters, and domestic laborers. This division of labor and public roles was not merely a practical arrangement, it was a reflection of the perceived natural order of things. A woman stepping outside these prescribed roles, perhaps by attempting to engage in commerce independently or seeking an education beyond domestic skills, would be met with skepticism, criticism, and often active discouragement. Her attempts to assert herself or seek rights might be viewed as an affront to both human and divine order. Constant barrage of messages, from childhood stories to daily rituals and legal pronouncements that underscored women's lesser status, created a powerful psychological and social barrier. It wasn't just about specific laws, it was about the very air women breathed, the expectations placed upon them, and the limitations imposed on their ambitions. The denial of justice was thus often not a single, explicit act, but a systemic consequence of a deeply entrenched belief system that positioned women as perpetually secondary, needing male guardianship, and inherently less capable of fully participating in or demanding fairness from the public sphere. Number 3. Trapped by ignorance due to lack of education. Imagine you are a woman named Ileana, living in a small remote community in 830 AD. You hear snippets of gossip stories from travelers and occasionally pronouncements from a visiting lord or cleric. But when it comes to understanding the complex laws that govern your life, the rules about marriage, inheritance, property, or even crimes, you are largely left in the dark. Your world is primarily oral, and formal education, especially literacy, is a luxury almost entirely denied to you. Across most of Europe in 830, access to education was severely limited even for men. For women, it was even more so. While some aristocratic women might receive private tutoring in basic literacy, religious texts, or household management, and some nuns in convents might achieve high levels of scholarship, these were very much the exception rather than the rule. For the vast majority of women, regardless of social class, formal schooling simply did not exist. Their education consisted of learning practical skills for household management, childcare, farming, or crafts from their mothers and other female relatives. This lack of education had profound consequences for a woman's ability to seek and obtain justice. Legal codes, however rudimentary, were written documents. Court proceedings, while often oral, relied on knowledge of established precedents, customary laws, and formal procedures. If Ileana could not read, how could she consult the written laws that governed her inheritance? How could she understand the intricate legal arguments being made in a court if she didn't grasp the basic concepts of property rights or legal standing? She would be entirely dependent on the interpretations of others, usually men, the Lord Scribe, the local priest, or her male relatives. Consider a scenario where Ileana's family faces a legal dispute over a boundary line, similar to Alara's case earlier. If Ileana cannot read the charter or the customary law describing the proper boundaries, she is at a distinct disadvantage. She cannot verify the claims made by the opposing party or even by her own male representatives. She must trust completely in their interpretation, which might be flawed, biased, or even intentionally misleading. Her lack of legal literacy means she cannot challenge procedural errors, understand the nuances of an oath, or even articulate her own claims in a manner that would be recognized as valid by the court. Furthermore, without education, a woman's ability to articulate her thoughts clearly and persuasively in public forums was often underdeveloped. Even if she were permitted to speak, her lack of formal training in rhetoric or logical argumentation would leave her vulnerable to being easily dismissed or outmaneuvered by better educated men. Her very capacity to comprehend the system meant to grant her justice was impaired by her exclusion from the means of acquiring knowledge. This isn't just about reading words on a page. It's about understanding the very concepts of law, precedent, and legal strategy. The denial of education thus functioned as a subtle but powerful barrier to justice, created an information asymmetry where women were perpetually dependent on men to mediate their understanding of the world, including the legal world. This dependence made them susceptible to manipulation, exploitation, and ultimately unable to effectively advocate for their own rights or defend themselves against injustice. They were effectively disarmed in the intellectual arena, leaving them vulnerable to those who wielded the power of knowledge and literacy, a power deliberately withheld from them by the societal norms of 830. Their very ignorance, consequence of systemic exclusion, became a tool of their ongoing disempowerment. Number 2, trapped by domestic violence without legal recourse. Imagine you are a woman named Beatrix, living in a small farming community in 830 AD. Your life is hard, filled with manual labor and the relentless demands of the household. But beyond the daily toil, your life is also marked by fear. Your husband, a strong and often volatile man, frequently resorts to physical violence both as a means of control and in fits of temper. He might strike you verbally, abuse you, or deny you food as a form of punishment. What recourse do you have? Where do you turn for justice? In 830, across much of Europe, domestic violence was rarely considered a matter for the formal legal system. It was overwhelmingly viewed as a private family matter, an issue to be handled within the confines of the household, subject to the authority of the husband or patriarch. The husband, as the head of the household, was often seen as having the right, even the duty, to discipline his wife, children, and servants. This right to discipline was not typically defined by law in terms of its limits, allowing for broad interpretation and often brutal practices without external accountability. If Beatrix sought help from her family, they might advise her to endure it, to be more submissive, or to pray for her husband to change. Seeking help from the local lord or priest would likely yield similar advice. Prevailing view was that the husband had authority over his wife, and interference in domestic affairs was generally avoided unless the violence escalated to extreme, life-threatening levels and became a public scandal. Even then, the response might be to mediate a truce, not to offer true legal protection or separation for the woman. Divorce was almost impossible, as discussed, leaving women with no legal exit from violent marriages. Consider the practical implications. If Beatrix were to flee her home, she would have no legal protection, no economic support, and no place to go. She would be considered a runaway wife, potentially facing social ostracism, the loss of any claims to property or dowry, and even forced return to her husband's custody. There were no women's shelters, no protective orders, no concept of state intervention to ensure her safety. Her only options were to endure the violence, to find refuge with relatives, who might eventually pressure her to return, or, in desperate cases, to enter a convent, which might only be an option if she had no children and if there was a suitable institution willing to take her. The lack of legal recognition for domestic abuse meant that women were trapped in a cycle of violence with no escape route. Their homes, which should have been places of safety, became potential sites of terror. The justice system, if it could be called that in this context, effectively sanctioned this power imbalance by refusing to intervene. The assumption was that the husband's authority was absolute, and a wife's suffering within her marriage was simply her lot. There was no concept of a woman's right to bodily integrity within marriage, no recognition of her personal safety as a matter of public concern. This denial of justice was particularly insidious because it occurred in the most intimate and vulnerable space of a woman's life. It meant that the very institutions meant to uphold order and fairness, the courts, the church, the community leaders, largely turned a blind eye to the private suffering of countless women. Their plight was rendered invisible, their pain dismissed as a private matter, leaving them entirely at the mercy of their husbands with no avenue for protection, redress, or escape. The very fabric of society, reinforced by law and custom, created a cage with no lock from which women in 830 had no legal means to escape. Number 1. Absent from power, no women in legal authority. Imagine you are a woman living in 830 AD and you find yourself embroiled in a legal dispute. Perhaps it's a claim over a small piece of land, a disagreement about a debt, or a false accusation leveled against you. As you approach the local court, whether it's a council assembly, a village moot, or a church tribunal, you notice something striking. Every single person in a position of authority, every judge, every scribe, every witness of note, is a man. There are no women on the bench, no women keeping the records, and certainly no women making the laws. This fundamental absence of women from any position of legal authority or influence was perhaps the most overarching and pervasive way. They were denied justice in 830, and laws were crafted by men, interpreted by men, and enforced by men. Their perspectives, their biases, their understanding of society, and their vested interests were the sole drivers of the legal system. There was no female voice to advocate for different priorities, to challenge existing norms, or to articulate the unique challenges faced by women. Consider the process of lawmaking. In kingdoms and empires of this era, laws were typically promulgated by kings, emperors, or powerful lords, often with the advice of councils composed exclusively of male nobles, bishops, and scholars. These men drafted laws that reflected their worldview, a world where women were seen as subordinates, properties, or domestic figures. It was incredibly rare for a woman, no matter how intelligent or high-born, to participate in these legislative processes. Their voices were simply not part of the conversation when rules were being set that would govern their very existence in the courtroom. This absence was equally stark. Judges, whether they were local lords, appointed officials, or ecclesiastical figures, were universally male. Their interpretation of existing laws and customary practices would naturally be shaped by their gendered experiences and societal conditioning. They would be the ones weighing a woman's testimony, deciding on the validity of her claims, or adjudicating disputes that directly affected her life. Without female judges, there was no one to offer an alternative perspective on complex issues involving female experiences. No one to challenge a prevailing bias against a woman's word, and no one to understand the specific nuances of her situation from a shared gender perspective. Even the scribes, the individuals who recorded legal proceedings and kept charters, were almost exclusively male. Their documentation, their choice of what to emphasize or omit, would inevitably reflect the dominant male narrative. This meant that the historical record itself, the very basis for legal precedent, was shaped through a masculine lens, perpetuating the existing power structures and biases. The impact of this complete male dominance in the legal sphere was profound. It meant that any laws that disadvantaged women, any interpretations that rendered them powerless, and any social customs that confined them to a subordinate status were unlikely to be challenged or changed from within the system itself. There was no internal mechanism for correction or reform that originated from a female perspective. The system was designed by and for men, with women's roles and rights largely defined by the needs and perceptions of the male-dominated society. This systemic exclusion meant that women were perpetually seeking justice from a system that was not designed to serve them equally. Their grievances, their needs, and their unique vulnerabilities were filtered through the consciousness of men who often unknowingly operated within a framework that devalued women's autonomy and rights. The denial of justice was not just about specific laws, but about the very structure of power that excluded women from the creation, interpretation, and enforcement of the rules that governed their entire lives, leaving them to navigate a legal landscape where their voices were often unrecognized.